Morning, Your Honors. May it please the Court. Derek Steichleather on behalf of the Appellant Hospital, and under Judge Lewis's direction, I'll have 5 minutes for rebuttal. The $261 million verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These 3 major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother. That did not give the hospital a fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39 such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Could you round out your understanding or your position as far as the immunity? Obviously, you feel it's too narrowly, the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity first expressly covers any act authorized by Chapter 39. I think that's the first important point because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39-303-3, subsections A and subsections F, that apply to the Child Protection Team. Dr. Sally Smith, in this case, is the Child Protection Team Medical Director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A in 39-303-3 gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
So you would agree that even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity?
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious.
Well, let's just take the claims as they are, the intentional infliction of emotional distress. If that did indeed play out, then would that be covered under the immunity as you just described?
I think a true case of intentional infliction of emotional distress would not. And I think what your question is getting at is this an absolute immunity? If a child is being protected, anything goes, and that is not the position of the hospital. It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side is that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy, because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice, and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go, can we go to the intentional infliction of emotional distress claim by the estate?
Yes.
Okay, there's the case of Nelson, which I'm sure you're familiar with, because you're relying on it for the intervening cause of the suicide, that would absolve any liability by the hospital. And so, in looking at Nelson, it allowed a claim of suicide to go to a jury, right, because they were remanded for trial. And so it talked about the difference between one being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition committing suicide. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the facts are that we have the hospital's position was that Mrs. Kowalski was, we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had mentioned that she was in some sort of mental state, as, maybe had relayed some information to them to that effect early on the admittance. And then you have, after that, you have, and I realize while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her? You have statements that the daughter's faking it. You have, mic is going out. You have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession as a nurse, and then challenging her as a mom for the way that she treated her daughter. So my point to all of that is that's like everything of the woman. That's like her whole existence. It wasn't just one thing that she was being challenged on, it was all of those things. Why is that not enough evidence on the issue that was the Nelson that they remanded for, not enough to go to the jury?
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act, and that has a almost non-existent causation requirement. FELA cases, the instructions to go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is a 1980 FELA case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to. And I think that the other part of your question I'd like to address is, how do we not feel for a mother who's accused of abusing her own child? And that ingredient is present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is always traumatic. It is always awful. It is always terrible.
Well, then on that point, following up on Joe, if the hospital's operating under a shelter, to what extent and what is the nature of any duties or obligations they might owe to the parents?
There are profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, the duty is to the child. This law exists for the benefit of the child and not for the parent. Because the parent is always outraged, is always upset, whether the allegations are true, whether the allegations are false, they are going to be devastated, furious, and they are going to sue. And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, we're talking about a minor, a 10-year-old minor. Don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the parents of the minor child who's a patient in the hospital, and can't those coexist?
They can coexist, but the legislature has made a clear policy choice, because in all of these cases, there is this fear, what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this, and if this is allowed to go to a jury will be angry about this. And the testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right. And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the, I think there were 5 dependency orders, was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
The parents were included that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity, and when the reason for this is the good faith belief. And I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities, and there is an inevitable conflict. These are always awful, terrible, raw, sensitive.
It didn't remove the parents' rights to be informed and to be involved in the decisions of treatment.
Certainly not as an absolute matter, but there is, for instance, when they want to do video monitoring, they want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe through the testimony was approved through risk management?
Yes, the assistant risk manager approved of that.
And
What's the difference? What does a hospital use as a guide to interacting with the parents to get consent or at least inform them? And in the case of the monitoring, just doing it on their own, it'd be the advice of the people who were involved in minimizing risk.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the kids where simply physical separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And the mother is not the patient of the hospital. And if it's presented as a medical malpractice case where, well, did you have advanced psychiatric experts, are you absolutely certain the mother had this problem? That cannot be the standard. The hospital has to
Well,
have.
I'm trying to get my arms around this. How is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather her fall to prove that the mom was right, or to prove that she actually was a victim of Munchausen by proxy?
No, there's no desire to create a fall or anything like that. And that among all the conspiracy theories, that has not been suggested that they wanted the child to fall. The idea was there is necessary for medical and for child abuse investigatory reasons to find out why is there this very strange, immediately apparent discrepancy between what they say the child can do and what she does right in front of their own eyes. There is a vast difference in her behavior from when the mother is in the room, from when the mother leaves the room. They are presented with a bizarre situation. This girl shows up and the mother reports she has been put in a ketamine coma that we took her to Mexico to do because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet as nopainhannah.com, and he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this hospital would ever give a child.
Was that was under the direction of a medical doctor here in the States? The referral was, right?
The referral to Mexico? Or
No, I think the referral to the doctor, was that under the advice of a medical doctor here?
Yes.
That she was being treated by?
you can find doctors in Florida that will sell you pain medications. And they got a $10,000 ketamine 4-day treatment from Dr. Kirkpatrick. Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus. There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems. And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agree to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just the year before. But her tolerance has grown so high that as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking massive amounts of ketamine because she's built this high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report. It is found as a matter of law. They had good faith reasons to file this report. It is immune conduct. But yet the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship. Those were all proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with the parent-child relationship. This is malicious prosecution. You just don't like this mother because she challenged your opinions, and you're out to destroy her. And
What's your end game?
I think the end game is that
you want a new trial? You want us to, if we agree with you, a new trial or strike through various damage items?
we certainly need to strike through the suicide claim. That is not appropriate. There is nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of decency, conduct utterly intolerable in a civilized community. This is child protection activity by licensed pediatricians, healthcare workers, who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct as the face of the hospital. The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on the jurors and the effect it had on their view of the hospital. This is a hospital that lies, cheats, and steals from its patients. It's rotten to the core. And when it got to closing arguments, the plaintiff said, you know what, just give us $1, because we don't have the evidence of this. They're thrilled they were able to say it for 8 weeks, but we don't have the evidence, just give us $1. The jury gives them $5 million even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include. I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by child protection team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, or whether they're contracted through Suncoast, but non-hospital actors as part of their child protection duties. And they are.
And were the ones you just laid out here, were those specifically laid out and authorized by the dependency court orders for them to do?
I don't know that the court says iPads, but the actor, it is the child protection team that is making these decisions.
You're saying simply because they are a child protection actor, whatever they do and they think is right is immune?
I'm saying that A, they're certainly not the hospital. B, the immunity should be broadly construed as a robust immunity. And I think there's a very strong presumption that when...
What's that mean? You say robust, is there a case authority that talks about that? Or what does that term mean to you?
I think it means that it reflects that there is a policy...
I know there's specific good faith requirements in 39.
Yes.
But I don't know if that's defined anywhere.
I mean, and the word robust actually, I think, comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that these situations are always terribly sad. And if angry parents can bring lawsuits that quibble over details, you were allowed to do this, but it didn't expressly say you could take the iPad. So I'm going to say you maliciously took my iPad in order to make me miserable. And I'm going to talk about how sad I was for 97 days. And I'm going to have experts refer to my hospitalization and sheltering as a captivity. I'm going to use this language of kidnapping, abduction, and, torture.
Was there an option where she could receive care when the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's her initial report. That deals with her initial report.
There are even two initial reports. There's an October 7th report and October 9th report. The October 7th report, the reporter says the parents are cooperating. They're doing what we want to do. And DCF's response is, well, then we're okay. Then if they're doing what you suggest, that we'll leave it alone. 2 days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is opened. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different matter and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on a 91-day sheltering 24 hours a day for months on end, who is able to get, just through testimony, someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And when they're saying she also constantly interrupted when my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You know, you've limited, they're worried about the psychiatric dynamic and the pressure being put on the child by the mother. And a clear stipulation is, or not stipulation, a clear part of the order is, you know, these are going to be monitored calls, and of course they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first report in October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested. In the light most favorable, we have to go with the assumption that they did detain the child. I can't identify what day, what time that happened. But there's also, throughout the medical records, repeated references to extensive communication, family meetings, and consent. They agreed to placing the nasogastric tube. They agreed to a colonoscopy.
And they later agreed to stay at the hospital
Yes.
at some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's some allegations here that they would only leave if the hospital would remove the Munchausen by proxy or the syndrome from the records.
So let me interrupt that fact. We do want you to answer the question, but you're in your rebuttal time.
All right,
But please answer the question, or else I get yelled at.
I'm sorry. Could you please?
What was that, is that an accurate depiction of what happened, that they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of the Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. The medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours, but the mother's intent, I want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert. And the Hopkins throughout admittedly said, we are not CRPS experts. But we are, professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic, and we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready, and they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue at trial, this meant we would have had to agree to it. It doesn't mean that. You can write, that's what you think. I disagree. And that's just what's thrown to the jury is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consent it. There's no right to do that, and there was no barrier to doing that. Thank you for the time.
Thank you. You'll have your 5 minutes.
Thank you.
Mr. Tanner?
Good morning, Your Honor. Mike Tanner, Gunther, Yokley, and Stewart for the appellees. Judge Smith, I'd like to begin by answering your questions and the 2 last questions that you asked, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity. But I would like to start out with your last question on on when the Kowalskis were told they couldn't leave the hospital. And you heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript. And Jack Kowalski testified there that they arrived on a Friday afternoon, October 7th, and he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not, or they'd be arrested. So 3208, and then look at his testimony at page 3265 and 66, where he elaborates on that. And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that because it's actually in the medical record. Look at the record at R109987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday after she'd had a conversation with Beata Kowalski that evening, in which Beata said, we want to take Maya out of here tomorrow morning. Tuesday morning would have been the 11th, to take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called. It's right in the medical record. And the documents that counsel referred to that show that purportedly the Kowalskis agreed to stay at the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those because what those actually show is that those are all dated the 12th or the 13th. After they've been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert and factual issues that they continue to believe that they can litigate here with you in this court. They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that it was for medical treatment, yet it wasn't in the medical file. Counsel said to you this morning that there was an assistant risk manager approved putting her in there. Well, it wasn't an assistant risk manager, it was the risk management department. And we have documents in the file we gave you that show the very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the brief in here this morning. And all those issues were submitted to the jury. And the jury found against them on those issues. And yet they want to litigate them again here in this court. So Judge Black, and Judge Smith, you asked this question too as a follow-up on what is the scope of the immunity. And I listened very carefully to my colleague here in answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. That is, the jury found torts in this case. And yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose, that would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief. I think it becomes clear there. Everything after the act of reporting, they say should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And the trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39203(1)A, immunizes certain types of conduct. It immunizes reporting And the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs. But the trial judge correctly ruled that the things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then he went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And your honors, there's no such thing as a good faith tort, especially a good faith intentional tort. And nor is anywhere in Chapter 39 tortious activity authorized or required. And so that was the trial judge's analysis, which we suggest was correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury in answer to one of your questions, Judge Smith. So, so that's partly why they want to exceed the statute or ask you to exceed the statute when they ask for what would essentially be blanket immunity. But the other problem is this. They ignore Section 1B. It goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And that, and the authority for that would be the Yamani case and the Floyd case that we cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So, Judge Smith, I do want to also address your question on Nelson. And I think you summarized quite well all the conduct that we laid out in our brief on the application of that case to the IIED claim. Two things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation. And I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again, they said it in their brief that, well, Nelson is an outlier, and also it's based on FELA principles. I think if you read the case, you'll see it's not based on FELA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial tort principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry it took me a while to get there. But you ask, what are the duties of the parents under the shelter orders? And I think it's important.
More specifically, what was the hospital's duties?
Yes, sir. What were the hospital's duties under there? And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, Judge Smith, this goes to one of your questions too, the parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya. They were to be allowed to have certain types of visitation with her. The husband and, yes, the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims. And those come right out of the shelter order requirements. I do want to address the points he made about Dr. Smith. The fact is, they said it in their brief. Dr. Smith did not present well as a witness at trial, and I'm sure they regret calling her. The fact it was that the plaintiffs played one deposition clip from her. It lasted about 30 minutes. The hospital called Dr. Smith to the stand and kept her there for quite a while. And so if there was any sort of prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim. And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was she guilty of medical negligence? Yes or no? But then it went on to say, were there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya. And so you really don't even need to reach the issue of Dr. Smith, because the medical negligence verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr. Vose, Dr. Tepa, Dr. Dees, who made the decision to terminate Maya's ketamine. And that's the basis of the medical testimony that Dr. Chopra testified that it was the termination of the ketamine, which was an efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal. And I also would like to, on a related point to what was going on in the hospital would like to give you the impression that everything that was being done to Maya, what she could see, where she could go, who could see her, who she could talk to, all of that was being controlled on a very granular level by the DCF. I want you to read the testimony of Catherine Beatty at pages 3962 through 3970 and 4000 through 4004, because she was very clear there about what it was that Johns Hopkins was dictating, what their discretion was, the decisions they were making through the risk management department versus DCF. And so it's a significant exaggeration to say that DCF was involved in the details of what Maya could do, the scheduling of phone calls, whether she kept her bathroom door open. That was all done by the hospital. Those decisions were made by the hospital. I think I've answered most of the questions, if not all of them, that you asked. Are there any other questions you would like to ask me at this point? Because there's one final point I would like to make, but I want to answer your questions first. All right, well, let me lead with this. I think on the damages, the hospital in its brief more or less went through all of the damage numbers and threw their hands up and said, this is all excessive. There's no evidence that supports any of this. Please reverse it all. Give us a new trial on all of it. more or less, that's what they said. If you look at the damage numbers, and the numbers are large, no doubt about that, but we have to remember that these injuries were done to a 10-year-old child who then would suffer those injuries for the rest of her life, which would be a long life from that point, from 10 years old to 70 or 80. And the medical testimony from Dr. Brewerton was that because of the events at Johns Hopkins, or he used the term events, she suffered permanent aggravation. She suffers PTSD. And then he said from the experience she had at Johns Hopkins, she suffers major chronic depressive disorder. And that testimony was not objected to by the hospital, and it was not, the admission of it was not challenged as a point on appeal in their initial brief. So that's the medical testimony. The damages testimony was tried as a unified damages case on economics. It was $15 million from Ms. Kirby, and they have not objected to that testimony, and they didn't raise it as a point on appeal in their initial brief either. So that testimony was established by competent substantial evidence, $15 million. If you then take the non-economic award, which totals for all the torts on Maya now, that totals $69.5 million. That's a 4.5 times multiple of non-economics to economics. This court, in the Ailes case on remand from the Supreme Court, left undisturbed a non-economic award that was 16 times the amount of economics. So we submit in that light, and remembering that this was a 10-year-old child, these numbers, even though they're large, look very reasonable. And so, again, unless there are questions, we would ask you to affirm, and we stand on our papers.
Thank you, Mr. Kidd. Give me your 5 minutes for rebuttal, sir.
Thank you, Your Honor. I want to emphasize that there is a difference between the evidence and the reasonable inferences that can be drawn from the evidence versus rhetorical expansion. And a lot of this case deals with, and something like ketamine efficacy. What are the reasonable, what is the evidence of ketamine efficacy? Maya Kowalski showed up at this hospital having not just been put in a ketamine coma, had her at, and the science is it's milligrams per kilogram per hour. But that coma in Mexico was at the rate of 3 milligrams, 4 milligrams, 5, 6, and 7 for the 5 days because tolerance builds. The day before she arrived at Hopkins, she was infused at 24 milligrams per kilogram per hour. And the doctor treating her said, "I'm out. I have failed to treat her. You need to take her to a hospital. That could be bile duct inflammation, but this has failed." She rated her pain 10 out of 10, her quality of life 0 out of 10, and she showed up screaming in excruciating pain. Her testimony is that my lesions were returning. The idea that ketamine efficacy is just the law of the case, that this worked and the hospital, ruthlessly just ripped it away to get the mother to kill herself is conspiracy theory. The evidence, and there's a conspicuous failure to specify what is the extreme and outrageous conduct. I hope the panel is unanimous that there's certainly not extreme and outrageous conduct that is clearly directed at the mother to get her to commit suicide 3 months after she last left the hospital. But things are thrown in there. Maya is asked on the stand, "Oh, did you have conversations during the last 10 days? Did they cut you off?" And she says, "Oh, I didn't even know I had that right." Well, the medical records from December 30th to January 7th reflect 13 interactions between Maya and her mother. Most of those were video chats. And I want to read into the record. If you look at the record at 108-560, at 111-906 to 910, at 111-915 to 916, at 112-602 through 611. That does not count the times when they called the mother and received no response, which are documented at 108-560, 61. So the hospital is whipsawed in the light most favorable standard does not extend to making unreasonable inferences from the record. Now, they say that risk management made these decisions, and they presented a chart, an org chart that says throughout the hierarchy, these are all connected. Therefore, risk managers are very senior, And you can attribute that. Well, Dominguez versus Florida Power and Light says for punitive damages, you need actions from the equivalent of the president or the primary owner of the company. We have nothing remotely close to that here. There's no basis for punitive damages. And the awards that they're trying to make sound reasonable, there was a battery claim for this social worker who was a grandmother hugging this child when she was crying and upset, and putting the child on her lap, and then she kissed her on the forehead and kissed her on the cheek. Jury awarded $19 million for those hugs. The allegation wasn't she was screaming in pain and she bear hugged her to torture her. This was acts of affection that the child didn't want. Does that state a cause of action for battery? Technically, yes. If my grandmother pinches my cheeks after I tell her to stop, I can sue her for battery. You have bodily autonomy. So there are claims that you can bring in the context of a sheltering case, but to say these awards were reasonable or that there was any basis for punitive damages is wildly off the mark. I want to also...
Can you just clear something up for me? With the reporting that was made initially on October 7th, it did not transpire to anything on the initial report. And the timing of if they wanted to leave, would they have been allowed to leave at that point in time?
I think based on the evidence, and we can assume...
When the initial report didn't go anywhere.
Correct. We can, on the light most favorable, and Mr. Kowalski's testimony, we can say that it shows the hospital did not allow them to leave or threaten them with arrest and call police officers. The issue then is whether 39395 authorizes that conduct. And it most certainly does for the first 24 hours. The statute then becomes ambiguous. It says the hospital can detain a child against the parent's will, and that is an express authorization to pediatricians and to hospitals. You can take a kid from their parents when they say, "Give me my kid," if you think this child is in danger. There's no dispute that the hospital, to their core, believed at all times this child was in danger in her mother's presence. Now, the court throws out the 24-hour rule, which is a rule that applies to DCF. The hospital can seize and the hospital has to immediately report. It did both. Then DCF has 24 hours to act. And other states write it differently. If you look at West Virginia statute, it says at 96 hours, the power to detain a child expires by operation of law. There are statutes that tell the hospital, you need to let go of the kid. But the false imprisonment here requires unreasonable, unwarranted, and unlawful action. And even if the panel sees 395 differently than we do and says, well, that wasn't lawful under 395, it is still reasonable and warranted that when you think this child could die if she goes out the door with this parent, because we are just terrified. And
it was okay for them to be transferred, even though those two reports had been made.
To transfer to Nemours? Yes, Nemours.
That would have been okay under 39, under the reporting, for them to be able to go to another hospital.
Yes, the Nemours was a safe place and had CRPS treatment and psychiatric care. So it checked whatever box.
And any sheltering would have transferred with that? Because we're going to a different jurisdiction. I'm just trying to figure out the logistics.
They would have to get approval from the dependency court, and I believe that there was no indication that was not achievable. Yeah, the parents are in agreement, the hospital's in agreement. I can't imagine if not DCF objected. But one thing I want to direct court to in my waning time is...
Counsel, I just want to point out you're over your rebuttal time, but wrap it up.
If I may, I would commend to the court again the court's January 14th, 2022 order on Chapter 39 immunity. It repeatedly swings and misses on what this immunity is. It expressly and explicitly ties it to reporting and nothing more. That clear error under Special versus West Boca, unless they can show there's no reasonable possibility that that error or the other two errors we've identified affected the outcome, we are entitled to a new trial. For that reason, the hospital asked for a new trial that does not include the suicide claims or the fraud claims, and properly applies Chapter 39. Thank you so much for your
Thank you
time.
very much. Thank you to both of you. Very well argued. Very sad.
Yes.
All rise.